Good day, everyone. I am Danica Gabriel Ruado. I am part of Group 9, Constitutional Law 2, and we will be reporting our assigned cases for today. The first case is People versus Tampal. The facts of the case are Luis Tampal, Domingo Padumon, Arsenio Padumon, Samuel Padumon, Pablito Suco, Darlo Suco, and Galvino Cadling were charged of robbery with homicide and multiple serious physical injuries in the Regional Trial Court of Zamboanga with Honorable Wilfredo Cotorena as presiding judge. However, only private respondents Luis Tampal, Domingo Padumon, Arsenio Padumon, and Samuel Padumon were arrested while the others remain at large. The case was set for hearing on July 26, 1991, but Assistant Provincial Prosecutor Wilfredo Guantero moved for postponement due to his failure to contact the material witness. The case was reset without any objection from the defense counsel. The case was called on September 20, 1991, but the prosecutor was not present. The respondent judge considered the absence of the prosecutor as unjustified and dismissed the criminal case for failure to prosecute. The prosecution filed a motion for reconsideration claiming that his absence was due because that date was a Muslim holiday and the office of the provincial prosecutor was closed on that day. And that motion was denied by the respondent judge. The issue is whether or not the postponement is a violation of the right of the accused to a speedy disposition of their cases, and whether or not the dismissal serves as a bar to the reinstatement of the case. The ruling of the Supreme Court is that, in determining the right of an accused to speedy disposition of their case, courts should do more than a mathematical computation of the number of postponements of the scheduled hearings of the case. What are violative of the right of the accused to speedy trial or unjustified postponements, which prolong trial for an unreasonable length of time. In the facts above, there was no showing that there was an unjust delay caused by the prosecution. Hence, the respondent judge should have given the prosecution a fair opportunity to prosecute its case. The private respondents cannot invoke the right against double jeopardy. In several cases, it was held that dismissal on the grounds of failure to prosecute is equivalent to an acquittal that would bar another prosecution for the same offense. But in this case, this does not apply, considering that the rights of the accused to a speedy trial was not violated by the state. Therefore, the order of dismissal is annulled and the case is remanded to the court of origin for further proceedings. The next case is Melo versus People. The facts of the case are, the petitioner was charged in the court of first instance with frustrated homicide for having allegedly inflicted upon victim with a kitchen knife and with intent to kill several serious wounds on different parts of the body, requiring medical attendance for a period of more than 30 days, and incapacitating him from performing his habitual labor for the same period of time. On December 29, 1949, at 8 o'clock in the morning, the accused pleaded not guilty to the offense charged, and at 10:15 in the evening of the same day, Benjamin Obelon died from his wounds. The evidence of death was available to the prosecution only on January 3, 1950. And on the following day, January 4, 1950, an amended information was filed charging the accused with consummated homicide. The accused filed a motion to quash the amended information, alleging double jeopardy, motion that was denied by the respondent court. Hence, the instant petition for the prohibition to enjoin the respondent court from further entertaining the amended information. The issue is whether the amendment of the information charged against the accused constitute double jeopardy. The ruling of the Supreme Court is no. It must be noticed that the protection of the Constitution inhibition is against a second jeopardy for the same offense. The only exception being, as stated in the same Constitution, that if an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. The phrase same offense under the general rule has always been construed to mean not only the second offense charge is exactly the same as the one alleged in the first information, but also that the two offenses are identical. There is identity between the two offenses when the evidence to support the conviction for one offense would sufficient to warrant a conviction of the other. This so-called same evidence test, which was found to be vague and deficient, was restated by the rules of court in a clearer and more accurate form. Under said rules, there is identity between two offenses not only when the second offense is exactly the same as the first, but when the second offense is an attempt to commit the first or a frustration thereof, or when it necessarily includes or is necessarily included in the offense charged in the first information. In this connection, an offense may be said to necessarily include another when one of the same essential ingredients of the former as alleged in the information constitute the latter, and vice versa. An offense may be said to be necessarily included in another when all the ingredients of the former constitute a part of the elements constituting the latter. In other words, one who has been charged with an offense cannot be charged again with the same identical offense, though the latter may be lesser or greater than the former. As the government cannot be with the highest and then go down step to step, bringing the man into jeopardy for every dereliction included therein, neither can it begin with the lowest and ascend to the highest with precisely the same result. Thank you so much. This is my part of our report, and the next topics and cases will be presented by my group mates.